Welcome back to Supreme Court Oral Arguments and Opinions, where I break down the latest developments from the highest court in the land. Today I'm focusing on the court's June 2nd, 2025 order list, which includes some fascinating certiorari decisions worth discussing. Please note that this episode is read by an automated voice. This order list tackles some of the most divisive constitutional questions in America today: gun rights, warrantless home searches by police, and election procedures that determine how we count votes. These aren't just abstract legal concepts. These decisions will directly impact citizens' rights, law enforcement practices, and even how our democracy functions. The Supreme Court regularly issues order lists that grant certiorari in some cases, meaning the court agrees to hear them, while denying certiorari in others. Both grants and denials can be significant, so I'll walk through several notable cases from this recent order list. Let's start with the 4 cases where the court granted certiorari before diving into 2 denied cases that sparked passionate written dissents from the justices. Each of these cases touches on fundamental constitutional rights and government powers that affect all Americans. First up is Bost v. Illinois Board of Elections. This case raises an important question about election law and legal standing, specifically whether federal candidates have standing to challenge state election laws that allow counting mail-in ballots after Election Day. The case began when Congressman Michael Bost and 2 Republican Presidential Elector Nominees filed suit challenging Illinois' law that allows mail-in ballots to be received and counted up to 14 days after Election Day. The plaintiffs claim this violates federal Election Day statutes. Both the District Court and the Seventh Circuit ruled against Bost, finding the plaintiffs lacked standing because the injuries claimed were self-inflicted and speculative at best. The implications of this case are substantial. The court's decision to grant certiorari signals interest in clarifying the requirements for candidate standing in election law challenges, potentially resolving inconsistencies in how lower courts evaluate injuries claimed by federal candidates. While the court's review is limited to the standing question and won't directly address whether states can count ballots received after Election Day, the ruling could significantly impact future election litigation by establishing clearer parameters for when candidates may challenge state election regulations in federal court. Should the court reverse and find that candidates have standing, the case would likely return to lower courts for consideration on the merits, potentially setting up another Supreme Court review on the more important question of whether federal Election Day statutes preempt state laws allowing ballots to be counted after Election Day. This case matters because over half the states have laws similar to Illinois' that permit counting mail-in ballots received after Election Day. The court's ultimate resolution could impact millions of voters and fundamentally alter how states process mail-in ballots in federal elections. The second certiorari grant involves a critical Fourth Amendment question in Case v. Montana. This case asks whether police officers need probable cause before entering someone's home in an emergency situation or if a lower standard is sufficient. The case originated from truly terrifying circumstances. William Trevor Case was charged with assault on a peace officer following a warrantless police entry into his home for a welfare check. The situation escalated tragically, ending with the peace officer shooting Case. Case survived the shooting but was subsequently convicted by a jury on December 8, 2022 of assault on a peace officer. After the conviction, the Montana Supreme Court upheld the verdict in a split 4-3 decision, finding the officer's entry was justified under Montana's community caretaker doctrine without requiring probable cause. The legal question boils down to this: when officers enter a home without a warrant to provide emergency aid, what level of certainty must exist that an emergency is actually occurring? The Fourth Amendment has long held the home as special, requiring the highest level of protection from government intrusion. But what happens when police believe someone inside might need immediate help? The petitioner argues officers need probable cause, a reasonably high standard requiring officers to have an objectively reasonable basis to believe an emergency exists before entering a home without a warrant. Montana argues a lower reasonable suspicion standard is appropriate for emergencies when officers are acting to preserve life rather than investigate crimes. Courts across the country are deeply divided on this question. Some circuits require probable cause for emergency aid entries, while others permit entry based on reasonable suspicion. What makes this case particularly complex is that some courts might be using different terminology while applying essentially the same functional standard. This split creates significant confusion for law enforcement officers making life or death decisions. The Supreme Court's willingness to hear this case suggests recognition that clarification is needed on the objectively reasonable basis standard for emergency aid entries established in the 2006 case called Brigham City v. Stewart. This case has enormous practical implications for police officers making split-second decisions during welfare checks and other emergencies. The court's decision will directly affect how law enforcement agencies nationwide train officers on when warrantless entries are permitted, especially during mental health crises, which constitute an increasing proportion of police calls. Whether the court requires probable cause or endorses a lower standard will strike a new balance between individual privacy rights and legitimate public safety concerns. A balance that could determine whether police intervention in emergencies happens too late or intrudes too easily into the sanctity of the home. Moving to our third case, GEO Group v. Menocal involves a procedural question with significant implications for government contractors. The question presented is whether government contractors can immediately appeal when a court denies their claim of derivative sovereign immunity. The case involves the GEO Group, which operates an immigration detention center in Colorado under contract with ICE. Former detainees filed a class action against GEO alleging violations of the Trafficking Victims Protection Act for allegedly forcing detainees to clean common areas under threat of solitary confinement and unjust enrichment for paying detainees only $1 per day for voluntary work. GEO claimed it should be immune from these lawsuits because it was acting under federal government direction, a concept called derivative sovereign immunity, or the Yearsley Doctrine. When the district court rejected this immunity claim, GEO tried to appeal immediately, but the 10th Circuit dismissed the appeal, saying such denials cannot be appealed until after the full trial. The question now before the Supreme Court is purely procedural. Should government contractors be able to appeal immunity denials before a full trial, just as government officials can with qualified immunity? The circuits are split on this issue, with 5 circuits allowing immediate appeals and 3 prohibiting them. This case matters because it affects the litigation risk for companies that contract with the government in sensitive areas. The court's decision will determine whether contractors must endure the full expense of trial before appealing immunity denials. The fourth certiorari grant concerns Hensley v. Fluor Corporation, which addresses whether federal law preempts state tort claims against military contractors operating in war zones. This case arises from a 2016 suicide bombing at Bagram Airfield in Afghanistan. The bomber, Ahmad Nayab, was an Afghan national employed by a subcontractor of Fluor Corporation. Winston Tyler Hensley, a U.S. Army specialist, was severely injured when confronting Nayab before the detonation. Hensley filed state law tort claims against Fluor for negligent supervision and retention of Nayab. The Fourth Circuit ultimately ruled these claims were preempted under the combatant activities exception to the Federal Tort Claims Act. The central issue is whether federal interests implicit in the Federal Tort Claims Act can preempt state tort claims against a contractor when that contractor allegedly violated military orders and contractual obligations. This gets into complex questions about federalism, military authority, and accountability for contractors in war zones. For military contractors, the stakes are enormous, billions in potential liability. For injured service members, the case will determine whether state law remedies remain available when contractors act negligently in combat zones. We'll, of course, cover these 4 cases in greater detail as the next term get closer. Now let's turn to 2 cases where the court denied certiorari but provoked written dissents from the justices. In Nicholson v. W.L. York, Chanel Nicholson, an African-American woman who worked as an exotic dancer, alleged racial discrimination at clubs owned by the respondents. She claimed being denied access to clubs in November 2017 and August 2021 because, according to management, there were already too many black girls working. The legal question involved the statute of limitations for race discrimination claims under 42 U.S.C. Section 1981. The Fifth Circuit ruled Nicholson's claims were time-barred because the limitations period began running when she first experienced discrimination at each club years earlier, not when the later discriminatory acts occurred. Justice Jackson, joined by Justice Sotomayor, wrote a passionate dissent from the denial. Justice Jackson argued that under the court's precedent in National Railroad Passenger Corporation v. Morgan, each discrete discriminatory act should start a new limitations clock. The dissent criticized the Fifth Circuit's approach as patently erroneous and suggested the court should have summarily reversed. This case highlights an important question about when the statute of limitations starts running for discrimination claims involving repeated discriminatory acts over time. The final case I'll discuss is Snope v. Brown, which presents a direct constitutional challenge to Maryland's ban on certain semi-automatic rifles, including AR-15 style weapons. The core issue is whether Maryland's Firearms Safety Act, which bans the possession, sale, and transfer of 45 specifically enumerated firearms that Maryland classifies as assault weapons, violates the Second Amendment right to keep and bear arms. This case sits at the intersection of public safety concerns and constitutional rights. This case has a complex procedural history spanning several years. After the petitioners filed their challenge in December 2020, the case wound through the federal courts. Most significantly, after the Supreme Court's landmark decision in New York State Rifle and Pistol Association v. Bruin in 2022, which established a new text and history framework for Second Amendment cases, the court initially remanded this case for reconsideration. Ultimately, the en banc Fourth Circuit upheld Maryland's ban in a 10-5 decision. What's particularly noteworthy about this case is that while the court denied certiorari, 2 justices wrote substantial statements explaining their views. These writings offer fascinating insights into the current state of Second Amendment jurisprudence. Justice Kavanaugh wrote a statement respecting the denial, acknowledging that under the common use test from District of Columbia v. Heller, petitioners have a strong argument that AR-15s are protected by the Second Amendment. He noted that Americans possess an estimated 20 to 30 million such rifles, which are legal in 41 of the 50 states. Justice Kavanaugh pointed out it's analytically difficult to distinguish AR-15s from the handguns at issue in Heller, since both are semi-automatic and used by law-abiding citizens for self-defense. Despite these observations, Justice Kavanaugh supported letting this issue percolate in lower courts before Supreme Court intervention, predicting the court should and presumably will address the AR-15 issue soon in the next term or 2. Justice Thomas wrote a more forceful dissent, arguing that Maryland's ban cannot pass muster under the framework established in Bruin. He emphasized that AR-15s clearly qualify as arms under the Second Amendment's plain text and criticized the Fourth Circuit for requiring challengers to prove not only that AR-15s are arms, but also that the right to own them falls within the historical scope of the right to keep and bear arms. Justice Thomas argued this improperly shifted the burden of producing historical evidence to the wrong party. Justice Thomas further critiqued the Fourth Circuit's conclusion that AR-15s fall within the historic exception for dangerous and unusual weapons, noting that a weapon cannot be banned under this principle unless it is both dangerous and unusual. With tens of millions of Americans owning AR-15s, Justice Thomas argued these firearms cannot be considered unusual. He concluded with a warning that the constitutional status of AR-15s is all the more urgent after a recent decision that could potentially allow ATF to regulate AR-15s as machine guns. The practical effect of this denial is the continuation of a patchwork of state regulations. Maryland's ban and similar laws in 9 other states will remain enforceable, while the 40 states without such bans can continue to permit civilian ownership of AR-15s and similar firearms. The regulatory landscape remains unsettled, with state-by-state variations likely to continue until the court eventually resolves the constitutional status of these weapons, which, according to Justice Kavanaugh, might happen relatively soon. That wraps up today's breakdown of the Supreme Court's June 2nd order list. The 4 certiorari grants will likely lead to significant rulings on election law, Fourth Amendment protections, government contractor immunity, and federal preemption in military contexts. Meanwhile, the denied cases with written dissents signal areas where the court may eventually step in to resolve circuit splits or address unresolved constitutional questions, particularly regarding discrimination claims and Second Amendment protections for semi-automatic rifles. Thanks for tuning in to Supreme Court Oral Arguments and Opinions. If you found this analysis helpful, please subscribe to the podcast and share it with others who might be interested. I'll be back soon with more Supreme Court coverage as the term continues.